So sustainability is supposed to be about saving the planet, but this talk is about saving companies, businesses from prosecution, because as a result of heightened public scrutiny and as a result of legal regulations, greenwashing now is no longer a marketing gimmick. It's not a marketing ploy. It's become now potentially a very complicated legal problem, and companies, retailers, manufacturers, whatever industry they may be involved in, have to be aware of the legal consequences that arise from making sustainability claims. I've only got about 15 to 20 minutes to discuss the regulatory landscape. So I'm going to this will be an overview, but by all means, if you want further details, contact me. I'm very happy to share this slide and any other resources. Now, before we discuss the regulatory landscape, and in this country, the two bodies dealing with sustainability claims is the Competition Markets Authority and the Advertising Standards Agency. It's probably important to define what we talk about when we talk about greenwashing. There's no actual agreed global definition, but the UN and IOS, the International Organization for Standardization, they have agreed on a general consensus. I can't actually see the slide, so I'm going to... But they agree on a general consensus. Greenwashing is the practice of misleading the public to believe that a company or its products are more environmentally sound than they actually are. And this definition is generally accepted by regulators in this country and Europe, and indeed globally, and it's enforced by the national courts. So it's a good working definition. But recent trends, as far as regulators are concerned, suggest that some companies, rather than making blatant lies, creating blatant lies in their products, are undertaking sophisticated deception. So they're making sustainability claims that they can't really support. And regulators have realized that. And so as a result of that, the law has evolved to try and capture those companies. And so you have, for example, examples last year in this country where leading sports brands like Nike and Superdry had adverts banned because they were using words like sustainability, eco-friendly, but when questioned, they didn't actually have the evidence to back up the use of those terms. And so ultimately, the Advertising Standards Agency decided that those adverts were irresponsible and were banned. So in applying this definition, there are a number of approaches that regulators take. Credence asymmetry, what does that mean? The trust gap. So when you buy a television, for example, you install the television, you're able to look at the picture quality, you're able to assess that it's good. So the search is good. You buy a burger, taste it, and you may decide the taste is good. So the experience is good. But when a company will say that they planted 1,000 trees to offset a flight, for example, the consumer does not know whether or not that's true. Similarly, regulators, and in that instance, the regulator will put the onus on the company to demonstrate that's true. And I'll come to how they deal with it in a minute. But the other aspect of sustainability claims that regulators look at is something called the vibe. Some companies, let's suppose they selling a bottle of plastic water, may suddenly tinker with the packaging. So the packaging feels really nice. They'll add some paper to the packaging, color the lid green, put a picture of the rainforest on it. And so when the consumer is buying that bottle of water, the consumer feels good about it. The consumer feels he or she is helping the environment. But actually, it may have nothing to do with sustainability in terms of manufacturing the packaging for that water. And so that kind of advertising would be caught as well, and that's called the vibe. But regulators also look at emissions. And this is where, for example, just to use this as, actually, let's use my phone, where a little bit of the phone case, perhaps 2% of the phone case, is sustainable, but the rest of it isn't. And so regulators will say, well, look, in making that sustainable claim, you need to tell the consumer that the rest of it isn't. If you simply say a little bit, if you simply say it's sustainable based on a portion of the product, that too is a misleading sustainable claim. So the onus, certainly in this country, as far as the CMA and Advertising Standards Agency are concerned, is it's up to the company now to demonstrate that thank you very much. There you go. It's up to the company now to demonstrate that they have the evidence to prove those claims. So what about the regulatory bodies then? So the primary body in this jurisdiction is the Competition Markets Authority. And their primary objective is to stamp out unfair commercial practices. But recently, they've got into policing environmental claims. And there's been a fundamental shift in their powers, which underscores just how important now it is for companies to take these matters seriously. The CMA used to be an advisory body where they would work with businesses and try and assist businesses to improve their practices. And then when businesses, in their opinion, got it wrong, they would have to take the businesses to court. So they'd need to rely on an external agency. But now the law has changed. It's a bit of a mouthful, but it's worth reading. It's the Digital Markets Competition Act. And the effect of that act, which came into force last year, is it gave the CMA new powers. And as a result of these new powers, the Competition Markets Authority doesn't need to rely on courts now to prove a breach of sustainability claims. They can actually go directly to a company and they are effectively judge and jury. The CMA can decide if the company has breached the rules, and the rules are, there are some rules set out by the CMA, some guidance that they put on their website as to how businesses should advertise their products and how they should make sustainability claims. And if they deem that there's been a breach of those rules, they can decide that they can also then decide on fining those businesses. And the financial penalties can be severe. It can be either 10% of a business's turnover or £300,000, whichever which is the greatest. The CMA also has the power to direct a business as to how it should conduct its undertaking if it feels that the business is sloppy when it comes to policies and audit control in relation to sustainability claims. And finally, the CMA also has the power to order the business to pay compensation to any consumers it deems have been harmed by sustainability claims. Now, along with the CMA, you also have the Advertising Standards Agency. So the CMA, they, if you like, deal with the big issues, the major issues that have a massive impact in the public. But the Advertising Standards Agency, they deal with policing adverts, whether they're online, broadcast, wherever they may be. The ASA are the police dog as far as adverts are concerned. And what they can do, they too have published guidance, which is parallel to the CMA guidance. And if they deem adverts are misleading insofar as sustainability claims are concerned, they can force a public apology, and it can cause significant reputational harm, and they can, of course, ban the advert altogether. And they've done that a number of times, and as I gave an example recently with Nike and with Superdry. Now, in terms of the rules globally, Europe, and in this country, post-Brexit, there was a difference between how this country and the rest of Europe regulated sustainability claims. But now, in recent times, there's been a mirroring of the rules. So in this country, effectively, what the CMA does is set out the principles, tell businesses what the goals are, and then it leaves it up to the businesses to achieve those goals in the best possible way. But in Europe, it's more prescriptive. So a directive has come into effect in Europe. It's empowering consumers for the green transition. ECGT, again, it's another interesting directive to look up. It's a good bedtime reading. But what the ECGT does in Europe is effectively it blacklists key phrases. It blacklists certain practices. And so while I accept there's a divergence at the moment between the UK approach and the European approach, one can nonetheless see that there is an increased mirroring between the enforcement provisions. So the law is becoming unified. And even in America, in the United States, we have the FTC Green Guide. And that too now is shifting from advisory to enforcement. So there's a harmonization of the rules across the board, which underlines again why sustainability claims are potentially legally complicated, and businesses must get it right in order to avoid the potential consequences. So I want to now deal with the common pitfalls as quickly as I can. Typically, retailers, for example, so historically, retailers would turn around and say, well, look, we're stocking this product. We didn't make the product. It's down to the manufacturers. So if the label in relation to sustainability claims is inaccurate, it's not our fault. But that defense has gone out now. So good faith is no longer an issue when it comes to regulating businesses. If there is an inaccurate sustainability claim, and you are a retailer and you haven't manufactured the product, you are still liable. That business is still liable under the existing regulation and as a result of the new guidance that CMA have issued. What the law says now is that whether you're a retailer or a manufacturer, the onus is on the business to ensure that the claims that the product is making about sustainability are true. So retailers have to double check with their suppliers, and even manufacturers have to check. When manufacturers receive the raw material to create the product, it's no good having an email from the supplier saying this is 100% cotton. The manufacturers have to double check that via a certificate. So this is the kind of guidance that the CMA have issued. And again, it demonstrates how now the law has recognized, because consumers don't have the same bargaining power, how are they supposed to understand whether these sustainability claims are accurate, says the law. The onus now is on the businesses to ensure that they have satisfied themselves that whatever products they're stocking, marketing, making are indeed sustainable. And it can go so far as a retailer deciding to stock a product at a particular aisle. So there was an example last year where a baby wipes company was suggesting that the product was sustainable, but in fact the packaging of the wipes and the moisture the moisture in the packaging to keep the wipes wet were in fact harmful to the environment. The wipes themselves were sustainable, but because of those emissions in relation to the packaging and the moisture, that company too found itself in breach of the environmental laws. So there's clearly a massive shift in trends so far as enforcement is concerned. And so going forward, what regulators now will expect, and in order to ensure your businesses are protected, it's very important you have a chain of continuity, almost like a sustainability passport, to demonstrate when you receive a product or when the product is made, if the regulator asks, and to support that sustainability claim, you're able to go all the way back and show that the business has carried out proper due diligence to demonstrate they've acted as efficiently, responsibly, and legally as efficiently and responsibly as possible. Of course, that does not mean that if a retailer is suddenly found in breach of sustainability claims, they're going to be fined 10% of their turnover or the £300,000, whichever is greater. The CMA will take into account the relevant mitigating circumstances, but the mitigating circumstances only come into play if the businesses can demonstrate they have some kind of compliance structure internally to ensure that they are playing lawful so far as these regulations are concerned. So look, I said I had about 15, 20 minutes. That is very much a whistle-stop tour of the changes in regulation so far as environmental claims are concerned and the way in which regulators are now enforcing these laws. I think the message I want to share with you in this conference is that these are matters that need to be taken seriously, because if they're not taken seriously, given the enforcement trends that we have seen already, we can see that this is only going to increase in the coming years, particularly not in this jurisdiction, but globally. Thank you very much. Thank you.